All, have we read the minutes?
Yep.
I'll make a motion to approve the minutes.
I'll second that motion.
December 6th.
All in favor of approving both minutes of the planning board and Cindy's typed up minutes, say aye.
Aye.
Aye. Okay.
Thank you.
So now, weed board member appointment for 2 applicants.
Correct. You had 2 terms on the weed board that were expiring December 31st. So we advertised for about a month. They were due yesterday at 5 o'clock, and these are your 2,
Okay.
and only 2 applications that were turned in.
Okay, so Alvin Meeks and James Lohman are the 2, and they are currently
They are
seated
incumbents,
people
correct.
anyway.
What kind of background do we got on these guys?
Only the best.
Dave Loman and
Jim
So Jane-
Bowman.
Jim Loman.
Jim
Okay. James
Lohman.
Lohman,
Jim
And
Loman and
Alvin.
yeah.
Alvin.
Alvin Meeks.
I just had to ask.
Lowman, I'm assuming.
Lommmen.
Oh,
You don't know him?
you know, I hear Jim's name all the time, but I do not know Jim. I may have met him, but I don't know him.
Do you know that other character?
Yeah, I know Alvin. And when would they take, when would they take office?
January.
January 1st, yeah.
They expired
They're-
December 31, so.
They're 3-year terms. It's kind of nice that we're actually doing applications for the board positions now as opposed to writing it out on cocktail napkins.
Mm-hmm.
I have some of those in the files from years back where they were written out on napkins.
What exactly is the weed board?
The weed board is a county-appointed board of 5 individuals that oversee the County Noxious Weed Act within Mineral County. So they're responsible for enforcement of the County Noxious Weed Act, working with state, federal entities for weed control across the entire county, working with landowners, trying to help them in controlling noxious weeds.
Okay.
Okay, there's the 2 applicants and the 2 openings. You want to review their applications, Dwayne, or do you remember who they are?
I'm happy with these guys.
All right, anybody have a motion?
I would make a motion that we accept Alvin Meeks and Jim Lohman as the newly, I guess they're appointed members of the weed board.
I'll second that.
Okay, all in favor of reappointing James Lohman and Alvin Meeks to a 3-year term on the board, say aye.
Aye.
Aye. Uh-huh.
I guess those go to Sydney for filing with.
Yes, 82% federal.
Okay, we have a special speaker today, but I'll let Senator Fielder do the introductions and any comments here, and then we'll get started. Senator Fielder?
Good morning, everyone. Thank you for having me today and for having Representative Ken Ivory. He's come up from Utah. He's a representative there in the House of Representatives. And I became acquainted with Representative Ivory because I'm the sponsor of a federal land study here in Montana. There's a lot of problems with management on federal lands. The management on the lands affects the communities and the people that live here nearest these lands, in and among the lands. And the legislation I brought is called SJ 15, and it's a study of federal land management problems and looking for solutions to those problems. So the federal land study that we're doing is identifying a whole series of the problems that we're able to determine. We've been surveying county commissioners throughout the whole state of Montana in the counties that have a significant amount of federal lands to find out what the issues are there. And there's been some very strong trends of what the issues are. One of the biggest ones is the amount of fuel loads that are built up in the forest where the lands are not managed and where we don't see timber production anymore. We're seeing catastrophic fire hazard, and of course then with the lack of timber production, we're also seeing a pretty steep decline in our economic ability as a community to provide jobs and to support families and that kind of thing. We're seeing a lot of access closures to the federal lands, and every county that we surveyed, we asked a series of questions, and not one of them wanted less access to the federal lands, but yet that's what we're seeing in all the forest plans that are coming out. The move is towards less access, it's towards closing roads, it's towards limiting uses. So part of what we're doing with the state study is also looking at all the possible solutions for how we can remedy these problems. And we're looking at a variety of things, from better ways to accommodate volunteers to be able to get out there and keep the trails open and keep the roads open, because a part of the issue is the funding. The federal government doesn't have the funding. We're in debt. They just can't support doing what they used to do, and we don't have the timber dollars that are paying for keeping those roads open anymore because we don't have the timber production. So we're looking at volunteerism. We're looking at ways to empower citizens in the local areas more so that your voice is heard more and how these lands should be managed, and also county commissioners. And another big element of this study that we'll be taking a look at is this idea that Representative Ivory has put together on actually transferring the federal lands to state control, to state ownership and state management, so that then the lands are managed under state law, and you cut out the federal bureaucracy, and the state can then manage the public lands in a way that suits the state and the people of Montana, and our representatives would be responsible for the policy that dictates what happens on these lands, rather than Washington, D.C. dictating the policy of what happens on these lands. And it's a pretty interesting concept. We're taking a good look at it, and I'm glad you're here today, and I hope you'll give a fair hearing to Representative Ivory, and he'll be available to answer any questions you have as well. Representative Ivory, take it away.
Thank you very much, Commissioners. Thank you. I'm honored to be here. We see your map up here. We see that same issue all around the West. I come from a state that's nearly 70% federally controlled, and we certainly feel a lot of the same issues. It's a big time. I'm so grateful for your senator. She's approaches things with such a reasoned way of looking at them, and we've learned a great deal. It's been kind of exciting as we've gone down this road, and we've started off, and a number of states have started into looking at the same question that we'll get into in a lot more detail. But what's fun is we're learning now from things that you're doing in Montana, and that they're doing in Nevada, and that they're doing in Wyoming, and that they're doing in Idaho. As we all look at this question, I want to start off with a little video that is your governor. A couple months ago at the Western Governors Association, I think he really framed the problem quite well in terms of the urgency of what we're looking at. We'll just kind of start off with that as a launching point.
For those of us in the western states, there's a real high degree of frustration when it comes to management of our federal forest lands. In Montana alone, the numbers are astounding. Since 2000, 6.3 million acres of Montana's forests have been affected by the mountain pine beetle. 4.3 million acres of forest and rangelands have been impacted by wildfire. The urgency is so apparent. Our forests should provide multiple uses. Managing our forests to accomplish and accommodate those various uses and benefits, it doesn't just happen. In Montana, I think we've done a relatively good job of doing that. We manage only 5% of the state's forested lands, but provide up to 15% of the annual timber volume sold in the state. And we do that while still protecting endangered species such as grizzly bear, bull trout, and lynx. On our federal lands, though, the story I don't think is quite the same. Wildlife habitat is degraded, watersheds are at extreme risk, endangering key fisheries and clean water. Fire dangers off the charts, threatening local communities and stifling recreation, to say nothing of the economies of our rural communities. In Montana, we still have a viable wood products industry with small and large mills dotted across the state. Yet without significant changes in available timber supply, we'll see more and more of those mills close. Interestingly enough, about 6 years ago, a diverse group of Montanans came together to try to figure out how we could address these problems. And after years of hard work, they came up with a plan that actually they could all support. So then they took their plan to Washington, D.C. And it was in Washington, D.C. that group of folks that had all come together on the ground in Montana learned the hard truth. That Washington, D.C. wasn't really interested in finding solutions to these problems. Congress was too polarized to get anything done. They were told, yes, forest management's broken, but no thanks, we don't want to try anything new. Unfortunately, now that they believe that the Forest Service and the overall system is simply incapable of getting anything meaningful done on the ground. We now can't wait for the federal government, though, to figure out a solution. It's up to us as Westerners to really bring answers forward, which brings me back to, I guess, my experience as a member of managing Montana's public lands. I think that model works well because there's a clarity of purpose, first of all. Second, with 5 statewide elected officials managing these lands, there's direct accountability for decision making. A third factor involves attorney's fees. People who sue us have no ability to recover their fees.
So you heard quite a bit from your governor on this situation. Now, to be clear, there's a 12-minute video that we cut this down for the interest of time. You can look at the whole 12-minute video, his introduction at the Western Governors Association, but we just kind of shortened that down in the interest of time. But think of some of the things that he said. The urgency, the environmental urgency is apparent. You know that. I mean, you're living here. You see it all around you. We were just talking before we started, right? The environmental urgency is apparent. And so within your state, brought a diverse group together. It's not about Republicans or Democrats or liberals or conservatives. It's about the land and the jobs and the tax base and providing a livelihood and protecting the land and protecting access. And so even in the state, diverse groups come together and they come up with a plan. It's hard. It may be hard, but in the states, we come up with solutions because we know that we have to educate the kids and take care of sick people and poor people and roads and public safety and protect access and recreation and the beautiful heritage sites that we have. It's not an either-or proposition. We understand that in the states. But so they take that to Washington and they say, Washington's not interested in solutions. And he says, we can't wait for Washington anymore. In the West, we need to bring solutions forward. And so that's really what we'll talk about for the rest of our time is potential solutions. Where do we go? What do we do? What are some options? And the starting point is to put facts on the table so that we can have a fact-based discussion about what are our rights, what are the opportunities, where do we go forward from here. Senator Fielder's been marvelous on helping bring a lot of that out. This comes from your Billings Gazette just last week. Montana has the most inaccessible federal lands. I mean, they're already being closed off under the policies right now, and there's so much more that we'll talk about. But so it really is, and is the key word, what your governor was talking about. You bring diverse groups together, and we can deal with greater environmental protection and resource development, greater environmental protection and productivity on the land. And that's what we do in the states. When you're in Washington and you've got 532 members of Congress out of the 535 making decisions on your land, most of whom have probably never been to Montana, you see all sorts of problems, rather than those whose lives and livelihoods depend upon the land, who are going to be more responsive and responsible. So this is the overview, okay? This is where we're going to go. We're going to look at the promises at statehood. Federal government promised all newly created states, all of them, from the original 13 West, he promised all of them it would dispose of the public lands. And the promises are the same. And we're going to look at that. It's already been done before, repeatedly. There have been states way worse off than Montana for decades. 90% federally controlled lands for decades. And they rallied under those same statehood promises and compelled Congress to dispose of their land. It's the only solution big enough. It's the only solution big enough to fund education, better care for the environment. Just like your governor said, we can take care of the environment and have the thriving timber industry. It's not an either-or proposition. Grow the economy locally and nationally and attain some level of energy independence. So this is where we're going to go. More information, there's a handout sheet or a sign-up sheet, but also any of you that text, and if you want more information, if you just text the word land to 58885, you'll get a series of emails. You'll get a text and a series of emails. We'll kind of walk through some of the stuff that we'll talk about, and you can get that over time. But here's the whole issue, right? I mean, in one picture, the picture tells 1,000 words. Well, in this case, the picture tells trillions of words, and we'll talk about why. Last night of our legislative session this year, had a group of Boy Scouts come up to the Capitol. They said, Representative Ivory, tell us what you're working on. And I gave them a little card with a copy of that map on it. And I explained that the red, they'd never seen anything like that before. I explained that the red represents the federally controlled lands. And just instinctively, their first question was, why? Why did they do that? Well, that question has led us on a kind of a 2-year odyssey, 3-year odyssey now. And it's really fascinating when you really ask that question and you expect an answer. Why the difference? We're going to look at that and talk about that. So let's start there. Why this federal fault line? We didn't create this. This is some federal policy that is just, at some reason, we've kind of had this arbitrary line that says, you know, over here more than 95% of the land is not federally controlled, and over here more than 50% of the land is federally controlled. Well, why? I had the opportunity to be on a continuing legal education panel to talk to about 125 lawyers on the issue of public lands. I'm a reforming lawyer, you see. That means I do a lot of work and I don't get paid anymore. So it's my full-time, part-time legislative job is taking up all the slack. But I was invited to be on this panel with a law professor from the University of Utah. And he was one of the chief guys that when we started looking at this, it's clearly unconstitutional. What are you thinking? I mean, federal government transferring the lands. It's clearly unconstitutional, just clearly. Not even close, just clearly. So we're on the panel together, and he goes first. And he puts up a map like this. And this is the annual average precipitation for the lower 48. And he says, you see how in the West, you see how that's different than in the East, right? You see that? It's different there, right? Well, therefore, the federal government keeps the land. You're all familiar with the arid clause of the Constitution, right? Right? I mean, the connection, right? I mean, your land is arid, therefore the federal government keeps the land. Now, what was really funny, amusing rather, sad perhaps, was that the 125 or so lawyers we're talking to, not one of them laughed. Not one of them even questioned. Really. But even if you accept that argument as silly as I think it is on its face, well, look at Oregon and Washington and Alaska that's not on the map. Alaska's 60% federally controlled. Arid? Washington? Arid? Oregon? Arid? Even on its face, that argument doesn't hold water, so to speak. But that was his first argument, right? His second argument gets way better than that. So, you know, your land is arid and rugged, therefore the federal government keeps it. Well, how do you get there from here? How do you just, illegally, with authority, how do you get there? Well, let's not let law and authority get in the way of a good story, right? So his second answer was this. He says, well, I've looked at the enabling acts of all the western states. The enabling acts, the statehood contract, right? Congress passes legislation that says if you do this, 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 and this, and you hold a constitutional convention, and your constitutional convention meets the terms laid out in this enabling act, then the president will declare you a state. So that's the enabling act, right? He says, I've looked at the enabling acts of all the western states, and they all have the same language. Forever disclaim all right and title to the unappropriated public lands. They all say the same thing. You've given up the land. That was the ransom that you paid to become a state. It's a dead letter, closed case, and he sat down as if to say, well, I rest my case. And you've probably heard similar things. Forever disclaim, you gave it up. You just gave it up. Look at that language right there. And he sat down. Well, I got up, it was my turn, and I didn't bother with dealing with the arid one because we only had about 15 minutes, and I mean, really. But we said, okay, let's look at this forever disclaim. Wow, Professor, you see that forever disclaim, all right, entitled to waste and unappropriated public lands. Wow, that sure looks like, a state with an enabling like that, act like that, gave up all their lands, right? Well, you see, that's Alabama's enabling act. And they were 90% federally controlled for decades at one point, and they're less than 3. And you see, forever disclaim, all right, entitled, and that's Louisiana's enabling act. And they were 90% federally controlled for decades until they mobilized and rallied and said, we can't educate our kids and grow our economy if you don't transfer our lands. And then you've got here, forever disclaim, all right, entitled, unappropriated public lands. And that's, my little remote thing here is going to goof up on me. That's Nebraska. Now, Nebraska's in 1%, right? Nebraska's a really interesting story because if you think of Nebraska here and Nevada over here, which one would you think was a state first, right? I mean, you'd think Nebraska was a state first, right? You'd be wrong. Nevada, their enabling acts were less than 30 days apart. Word for word, the same language on the disposal of public lands. Nevada's made a state in 1864. Nebraska's not made a state until 3 years later. Nebraska goes from more than 30% public land to 1. Nevada goes from 86 to 81. In that same time, same language, same terms. Well, why?
And when you say public, you mean federal?
Federally controlled, right? Yeah, federally controlled land, right. So then you've got here, forever disclaim, all right, entitled. Well, wow, if you read the rest of the sentence in some of these enabling acts, it says, until title thereto shall have been extinguished. You're grounded until. Well, that gives you some hope that there's an end to it, right? That word until has some meaning. When you read the rest of the sentence, it says, until title shall be extinguished. Well, that means get rid of title. That means dispose of title. That means you're not supposed to keep the title. And we'll look at some background and context on that. But you see, this is, that's North and South Dakota's enabling act, just to your east. And North Dakota went from more than 50% public land to 4. North Dakota today, they get to control 100% of the access to their land. They get to govern themselves. That's what this whole nation was founded upon, self-governance. They get to govern themselves. They keep 100% of the mineral royalties of things they develop in their states. They're putting billions of dollars into schools, billions of dollars into the buildings, billions more into classrooms, billions of dollars into roads. They've got tens of thousands of jobs just looking for people because they get to govern themselves and control their own resources. And that's their promise at statehood. Well, this right here, when you think about that, forever disclaim all right and title until title shall be extinguished. Well, that's Montana's enabling act. Now, you don't just have the same language as North and South Dakota. It's the exact same document. In many ways, your case in Montana is so much stronger than ours in Utah. We have that same language. You have the same document created 4 states. Think about that. How is it that under the same document, same language, they dispose of all the land to 2 to your east, but not to Montana and Washington? Why the difference, right? Well, that's the question we've been asking. Why the difference? Now, also in your enabling act, it says this. Now, those that'll just throw out those 6 words and say forever disclaim, never mind, we want to go back and look at what they meant at the time, but they forget this part of your enabling act as well that says 5% of the proceeds of the sales of public lands which shall be sold shall be paid to the state for the support of the common schools. So part of that agreement was you're going to sell the land and we're going to use that to educate our kids. Does it make any sense that we would say, we're going to rely on you to sell that land so we can fund education, but you just take forever if you want to do anything to dispose of it? Well, it doesn't, and it didn't then. It doesn't and it didn't then make any sense that we would agree to forever disclaim title and they would never dispose, therefore we can never tax. And we'll look at some of that as we get going as well. Let's see if I can get my little remote thing going back here. But so that's on the language. So here's the question. If the promises are the same, that forever disclaim all right and title, and you've got states that have gone from more than 90% federally controlled lands to 2 and 3 and 1 and 5% today with the same promises, well, maybe that doesn't mean we gave it up forever. Maybe it means something different because they've got the same language and they disposed of their land. Maybe we need to dig a little deeper and find out what that meant. And that kind of raises the question, why does the federal government control 50% of the West anyway? Why did they have title in the first place? In a nation that was founded on this principle of life and liberty and property and self-governance, why is the federal government controlling 50% of the land in the West? We thought that was a pretty valid question, so we looked into that. Well, come to find out that this question really starts back in about 1763. So you've got the king granted the colonies in their colonial charters, and they made the colonies, and to 7 of the 13, they say you can have claims to the western lands. And they granted them various claims to the western lands to 7 of the 13 colonies. Now try that with your children. That may work, from Utah, we can talk about having 13 kids and use the children example, so work with me here. But try that with your kids, right? 7 of you, you get to inherit the ranch. The 6 of you, good luck. Right? But that's how it started out. So 7 have claims to the western lands. That word is important too. They use that word claims. 6 of them don't. Well, 1776, right? The king was going in saying, hey, those trees are mine, that land is mine, your stamps are mine, if you meet, you can only do it with my permission and all the rest. They declare independence, lives, fortune, sacred honor, firm reliance of divine providence, we mutually pledge our lives, fortune, sacred honor, right? And off they go. Against the most powerful military, well-funded, well-equipped military in the history of the world. They didn't have an army, they didn't have a navy, they didn't have uniforms, they had nothing. And off they go. Well, they start into this war, and by 1780, they're completely out of money. The war's not over. The British are still the most powerful, well-funded, well-equipped military in the world, and they're out of money. Can you even imagine? I mean, think about that for a second. How did we ever become a nation in the midst of that? How did we get through that? That seems impossible, doesn't it? Well, they started figuring out we've got to keep going forward. As impossible as it seems, we've got to keep going forward. How do we fund this? Well, you've got a nation that is already just struggling to begin, but the 7 states said, we got an idea. We'll take our claims to these western lands and we'll sell some of our claims to those lands to raise our share. You 6, good luck. All right? You go raise taxes, you do whatever you want, but we're just going to sell some of our claims to the western lands. 6 states weren't very pleased with that. They said, no, wait a minute. We're putting our blood and treasure into this undertaking, and at the end of the day, you're going to be these big landed states, and we're going to have to tax our people. They're going to leave our states, go to your states. This doesn't work. It was such an intense debate. They called it the Great Embarrassment. In fact, in the writings of the day, they said that was the question of the day. How do we fund this going forward, and how do we deal with this issue of these western lands and the equity of all of that? It was the great embarrassment, the great question of the day. Well, here's what they did. These states, now there was not a national government at that time, and there certainly wasn't a national government that could deal with questions of owning or doing things with land. The states came together kind of in a form of a compact, like a Colorado River Commission or what have you. And they did this resolution on October 10th of 1780, and they said, be it resolved that the unappropriated lands, which is what we still call them today, that the unappropriated lands that may be ceded or relinquished to the United States by the states shall be disposed of for the common benefit. That meant pay the debt of the war. And be settled and formed into distinct republican states with the same rights of sovereignty, freedom, and independence as all the other states. And this part down here, and they will be granted and settled at such times and under such regulations as agreed on by Congress. They will be granted and settled under regulations that but they shall be disposed of to create new states, use the proceeds to pay the debt. Based on that, New York was the first one to cede their lands to this compact of states and said, we're going to cede it to create new states, use the proceeds to pay the debt. No other use or purpose whatsoever. They said that right in their deed of cession. No other use or purpose whatsoever. Other states ceded their lands as well. Georgia and North Carolina, they don't cede their lands to then the United States until 1802. Not until after the Constitution, they're still working off of this agreement. They called this a trust agreement. Courts have called this a trust agreement. Presidents and Congresses, states in their resolutions have called this a trust agreement. Think about that for a second. If you've got a trustee, what does a trustee do? They hold title, right? They hold title to the land. The tax notices go to the trustee. Can they do whatever they want with the land? Well, no, they can only do what the agreement says. They can't go sell the land and go book the cruise. They can't go say it's mine, I'm going to do whatever I want with it, but they do own title. But they own title with the most sacred duty known in our law. They call it a fiduciary duty, the utmost good faith and loyalty. But they do in fact own title. That's what they called this agreement. And everything on the public land starts right here, which is why this history lesson is important. Because why they own title to the land is important. Now, we've forgotten this over the centuries. They've forgotten this over the centuries, and it's turned into this, well, it's kind of like the property law of 2-year-olds. If I can touch it, it's mine. If I can see it, it's mine. If it's yours, it's mine. If I've ever been there, it's mine. And it's kind of evolved into that. Well, it's important to know the authority and where it starts from. Thomas Jefferson, after they win the war, same thing. Jefferson says, don't interfere with the primary disposal of the soil, that trust agreement that we established, nor with any of the regulations for securing title in the soil to the bona fide purchasers. And the states will be on an equal footing with all the other states. You see this creation of states and this issue of disposing of the public land and equal footing, they always went together. And we'll see some of that in just a minute. 1787, the Northwest Ordinance is the enabling act for 5 of the states northwest of the Ohio River, Ohio and Michigan and a bunch of others. Well, same thing. They'll be on an equal footing. New states, don't interfere with the primary disposal of the soil. You see this central government now under the Articles of Confederation, soon to be under the Constitution. They're just a trustee. Their job is to dispose. We worked on that great embarrassment question on how we would fund the war, on how we would ever get to the point of becoming a nation. Don't interfere with that. That's such a sacred, solemn compact. Courts and Congresses have called it that, in fact. Don't interfere with that, or with any regulations for disposing of the soil. And then we get to Article 4 of the Constitution. This is the provision in the Constitution that deals with the Western lands. It's Article 4, Section 3, Clause 2. Look at what it says. Congress shall have the power to dispose of and make needful rules and regulations. Remember the language from 1780 and 80.